So, welcome, Mr. Williams. Please identify yourself for the... Kate, come on up. Please.
Commissioner Frederickson, members of the board. I'm David Williams of Williams Consultancy in Fillmore County. I am speaking in opposition to the proposal to release the Erickson property from the Minnesota Sands EIS at this time. I'm here to talk about process. There are essentially two processes for releasing the Erickson property: scoping and variance. Scoping has not yet occurred and is about to begin. Mr. Frick has informed the EQB, he informed you today that he is ready to begin the scoping process. The scoping process is important because it identifies, one, the mine sites that you put in your order a year ago, and it also describes some of the environmental impacts or potential environmental impacts of those mining sites. And that's a part of the scoping process and a part of the process of moving along. The variance process. Erickson has not applied to the EQB for a variance. Executive Director Seufert stated that in his letter to Houston County Commissioner Dana Chomi, dated April 29, 2014, a copy of which is in your board packet. In his explanation of environmental reviews, Seufert cites the prohibitions on county government permitting decisions and on beginning construction and mining under Rule 4410-3100. The variance process contained within that rule. Seufert further says, quote, "The EQB has not received a variance application regarding the Erickson mine." And then he cites Rule 3100. The purpose of that rule is not just to make a proposer jump through some process hoops. It's to try to get Erickson to complete an application that shows the anticipated environmental impacts of what he is doing and what he's trying to get released from doing. Erickson is not just a guy saying, I'm not going to mine anymore, I'm going home and not doing anything. He's going to mine. He's going to mine the very same silica sand that he was going to mine a year ago with Minnesota Sands. It's interesting that there is no recommendation from the staff to let Erickson out. You know, the staff did not take a position on this. So is it contemplated to let Erickson out of this today just on the scant information that you have gotten from Erickson, Scanlon, and Frick today? Is that it? For you to make your decision on whether it is appropriate to let him out of that EIS that you had ordered a year ago? I don't think so. Even if you are inclined to release the Erickson property from the EIS, you should at least require them to complete the EAW process that was well underway in 2012 and early 2013. And remember, that was a petition process that was initiated by neighbors and residents and people in the community that was published in the Monitor, accepted by Houston County, and began. It has engineered documents. It has a draft of an EAW. The only thing that pretty much stopped that EAW was you guys taking it over as the redesignated RGU. That environmental review needs to be completed. If this proposed site were to be located in an industrialized area of Houston County, one might be tempted to say no harm, no foul. Let the guy go and let him mine whatever he wants to mine, but it isn't. This proposed location is in one of the most environmentally sensitive areas of Houston County. Two designated trout streams, the Root River and Ferndale Creek, the major bike trail in the region, along the historic Bluff County Scenic Byway, a golf course right across the road, a fish hatchery, sensitive bluffs, and quiet rural residences and farms. There's nothing else. There's no commerce. There's no industry in that area. Please do this thing right. Make Erickson go through environmental review for once, or at least explain why he should not be required to go through environmental review. Take adequate time to confirm the facts that have been presented to you today with all of the questions that you have had before you make a decision. please don't try to make a decision just based upon this scant testimony that you've gotten today. Thank you.
Thank
Any
you,
questions?
Mr. Williams. Questions for Mr. Williams? Seeing none, thank you very much. I'd like to ask, pardon me?
Excuse me, Mr. Chair. I heard two questions from the board that I felt the staff could help with.
Please.
First of all, the first question was as to what in 1992 the threshold was. And in fact, I can tell you that due to our sonars, the non-metallic mineral mining of 40 acres was in place since 1992. The shoreland categories, those thresholds were put into place in 2007. So just a clarification, 1982 was when those were instituted. And similarly, the related actions EIS, I heard that there was a question about that, and I just wanted to clarify that that is for multiple EIS level projects, just to re-go over that's multiple projects that each by themselves are at an EIS requirement. So unless there are any follow-up questions, I just wanted to provide that response.
Questions for Kate? Seeing none.
Thank you, Mr. Chair.
Thank you. Chairperson Walter. Welcome to the board.
I'm Teresa Walter,
Teresa.
Commissioner in Houston County, and actually I think everything's been covered by Katie very well what I was going to say.
Well, given the fact that Houston County is referenced at least in every breath here, it might
Exactly,
be
we're
good
here.
to hear a little bit
Two of us commissioners are for sure this
from your
afternoon.
perspective. So thanks for being here, Teresa.
And we have been dealing with this, and we're actually just here to clarify whether the EQB is the RGU for this project, because from our understanding at this point, the Erickson mine is not part of Minnesota Sands at this time from the papers that we have seen, and they're seeking a renewal of that conditional use permit, for construction sand only. And you do have all your information in your packets that we have also.
Commissioner Stein?
Thank you, Mr. Chair. Thank you for being here today. A question, were the EQB to determine that the Erickson's property was not subject to the EIS and would be, therefore, not, the EQB would not be the RGU for the project, would Houston County intend to take up the question of environmental review on its own?
It would go back to the Planning Commission. They have to, even for all conditional use permits, they have to meet all state standards through the MPCA and all the state government bodies. And also they can add more conditions as needed for the up-to-date situation.
So in other words, it wouldn't necessarily roll back to the way it used to be?
It would go back, but the Houston County would make the decision as a new governing unit.
RGU, and we would be,
RGU.
You asked the question and I asked legal counsel, and we are the RGU until
Yes.
we act.
And that's really what we're here for, is to get a clarification, whether you're not going to be the RGU anymore, and it would go back to us.
Commissioner Zilli.
So this 60-day period, what day do
We-
you view that starting?
We had a 60 days starting February 27th, but we extended it another 60 days with notification. So we actually have 120 days.
So you have
And
not,
that is due, I believe, June 27th. I figured that right.
so in terms of complying with state statute and the DNR and PCA standards, that has not been addressed and it hasn't been taken up yet because there
Because
hasn't.
you are the RGU at this point.
But you would fully intend to deal with the issue of the trout stream question, obviously, because it is
Yes.
now in statute.
Right. Well, for silica sand mining anyway.
Correct.
So, Mr. Chairman,
Commissioner Lamb?
the decision as to whether or not a permit is needed for the trout stream setback is not up to the county, it's up to the department.
It would move on to the DNR.
It is in your department's
Yes,
hands. So
exactly.
Absolutely.
Right. And they have to meet all those conditions with all state agencies.
Commissioner Thomas.
Commissioner.
Could call you senator or something.
Kate, could you do me a favor and on the screen you had a definition on the mandatory categories. Maybe it was just EIS and I'm remembering it incorrectly, but if EAW was in there, but it had the 2013 legislation that identified specifically silica sand, because there just seems, at least for me, and I'm hoping I'm not the only one who has this question, the definition on silica sand. Is it the source material or is it the intended use? And maybe by raising this question, I'm opening a whole new can of worms, but I'm just curious on that because the EAW threshold's there. 40 acres to a mean depth of 10 plus feet. And then we have, the fourth bullet, which identifies legislation regarding silica sand facilities. And I don't know if anybody here can provide insight into the definition of silica sand. Is it the source material? Is it the...
Mr. Williams is jumping up and down here. Come on up, David.
I would ask what makes him a professional.
You're welcome to come up and also testify, Mr. Erickson. So
I'm David Williams again. The definition of silica sand is contained within the 2013 legislation itself. It tells you that it is a high quartz mineral, and it goes on further to describe what silica sand is. Silica sand is what Mr. Erickson has as his mining site. And so the legislation contemplates not what the end use of the mineral is going to be. It really focuses on the mining activity. The legislature didn't care whether silica sand coming from Mr. Erickson's site was going to be used to do a bridge, to frack a mine, or to make granola or ice cream. It doesn't matter. It is silica sand, and that's exactly what silica sand is. It's a mineral.
thank you, Mr. Williams. Mr. Erickson, please.
I'd like to add to that, there's silica in every piece of dirt in this state, every rock, and every other mineral, there's silica. So the definition of silica is so broad that we would not be able to pinpoint that here today.
All right, thank you very much for both of your comments. Other questions?
Just, Mr. Chair, I have a question for staff. I just wanted to be clear. I'm looking at this. I looked at this earlier, and I think I made the correct conclusion, but I'd like it to be reaffirmed by staff. Due to the size of the Erickson mine, there's nothing in the newly legislated categories that require an EAW for this mine to continue.
Okay.
Mr. Chair, members of the board, ultimately the RGU is required to review the thresholds, and remember those are for mandatory reviews, but any projects that are determined to be beneath the threshold of the mandatory review and yet above the threshold of the exemption would still apply for any discretionary reviews that an RGU wanted to move forward with. So you're right, the numbers seem clear that 19.11 is still below 20, but that does not eliminate the potential for a discretionary review.
And the discretionary review would be called by the RGU.
Correct, correct. So if that were determined, as I said, the mandatory categories also identify the RGUs. And so in this case, it's the local government unit. If that local government unit determined that because of the nature of this project, there was a need for a discretionary environmental review, regardless of that size, well, as long as it's not an exempt project, then that project could be done, an environmental review could be done, and EAW specifically.
Mr. Chair, was it staff's assertion or was it the zoning administrator's comment? This is the smallest, about 140. What was it? 140 similar situated mines in the county. Was that a correct statement that I heard?
The EQB staff did not make that assertion. You can certainly ask those.
Okay. The zoning administrator is indicating that he made that statement.
Thank you. Other questions? If not, I'd like to, first of all, thank you, Chairperson Walters, for coming up and participating in the process. Kate, I'm sorry.
Thank you, Mr. Chair. And maybe this is for staff, I think. So we've been focusing on the Minnesota Sands and the Ericssons, just the dissolution of their business relationship. And I guess I hadn't thought of it from the, so is the perspective of our phased action, or the EIS that we made ourselves, the RGU for last year, is the focus of that, is it that we're responsible for the EIS in the named mines, basically, or anything that Minnesota Sand puts forward? And I guess I'm struggling with that. So it's basically, we're focusing on the dissolution of Ericsson's from Minnesota Sands. And is that the question when trying to answer the question before us? Or is it the question that we said we're the RGU for these separate mines who are brought together by Minnesota Sands? Am I being clear on that question?
Mr. Chair, members of the board, your legal counsel might be able to answer that. Will be helpful.
Okay. I would say that because if you look to the findings of fact that you have from March 20th, 2013, they say in the matter of the request, okay, sorry, this is the current one. If you look to the one that was done in March 20th, 2013, it says, in the matter of a request to designate a different responsible governmental unit for environmental review of multiple silica sand projects proposed by Minnesota Sands LLC in Fillmore, Houston, and Waconia counties. At the time of that, they listed out projects including the Erickson mine. So the findings of fact that this board entered at that time was based on the information this board had at that time. Now we're coming into new time. It appears that the findings were about Minnesota Sands, and that was the key proposer of that, not these individual mine sites. They were mentioned because they were trying to determine whether or not, I think, thresholds would be done, what you as a board would be looking at in terms of redesignating the RGU, what would make the most sense. So it was providing you information, but it wasn't saying for the Erickson mine or for the Jones mine or for the Smith mine. There was never that level of detail. So I think looking back in that and reading the findings, I would say that it deals with whether or not, I think the question before you that staff started with, which is whether or not the Tracy Michelle Erickson mine property of 19.11 acres specifically in Houston County, whether that parcel piece mine is a related or is a phased action to Minnesota Sands and all of their multi-county projects that they have under the one umbrella, Minnesota Sands, Minnesota Provident LLP. I hope that provides clarity.
Well, it does provide clarity, I think, but it also provides a significant amount of confusion also, because if that is the case and you're dealing with Minnesota Sands, then what are we doing here today? We should be just waiting for Minnesota Sands to submit the list of sites that would be considered phased and connected, and if Erickson Mine is not in that list, then they'd be out of the list, wouldn't they? Or any others that would not be submitted with the list that Erickson or that Minnesota Sands is submitting.
Mr. Chair, yes, in my view, I am being asked of a set of unknown size, of unknown places, to declare that a known place is not a part of the set of what might be known.
Proving the negative. In other words.
I have a hard time making a decision in that light because I don't know when I'll make the other decision, and I'm interested in making that other decision. I want to know what we're going to do.
So,
and I think the people who live in the area want to be served by this board's actions, not, And I understand Mr. Erickson's plight. I just am not happy that we don't have a cost agreement. We're not discussing the scope of the EIS rather than the scope of the not EIS.
It's perfectly clear.
Well, Mr. Chair, I think
Mr.
staff guidance on phased and connected actions is where we should focus our energies rather than on what we don't know and what may happen in the future. The definitions of phased and connected actions provide clear guidance. I believe that's why those that language was installed.
Mr. Chair, members of the board,
Okay.
because the municipal stands multi-site EIS was initially defined as multiple phased actions to exceed that threshold, we felt that it was appropriate to revisit those same concepts. So I hope that was helpful and not more confusing.
Mr. Chair, I have a related question, and that is,
Kristen.
Kate, when this EIS goes forward, I know it's one of the prime duties of the EIS and the RGU to define the project, the potential areas of impact. Would the project, looking at it purely from an environmental perspective, or primarily from an environmental perspective, would the EQB EIS be prohibited from scoping anything that is not named by Mr. Frick as one of his projects? When the EIS goes to look at cumulative impacts, can it only look at cumulative impacts that might be related to those specific sites? Is there anything broader that happens in the EIS process? Or are we basically doing EISs for his help? Just say there is a trout stream issue that the expertise of the EQB comes up with, and it's more complicated. The trout streams, or some of the potential impacts are more complicated, and they might involve other. Could they involve anything other than those sites that Mr. Frick is naming as his sites? Can the EIS scope and examine impacts from anything other than those specific sites that he names?
Mr. Chairman, of the board, I will attempt to answer that.
Okay, if it's not a question that's answerable, don't try. Let's just say it's not.
Well, let's take a step back and talk again about cumulative potential effects. Cumulative potential effects are an analysis that need to be done as part of any environments review and should be considered, as I said, EQB staff believes that it's on an impact by impact, case by case basis. So for an EIS, it should, as part of the review those resources, whether they be water resources or air resources, within the context of existing projects, as well as for future projects where I said where the expectation has been laid within that environmentally relevant area. And again, the environmentally relevant area could be broader for certain types of effects, such as water resources, or it could be more limited, such as traffic resources or traffic impacts. So, so a cumulative potential effects analysis occurs within that review. But a project, of course, is defined by a project proposer because they, of course, are the one proposing said project.
That's clear.
All right, we're going to have to roll on here a little bit in a few minutes, but Commissioner Rothman?
Yeah, just, I don't know if this muddies the water any further or not.
Probably does.
Or makes it even clearer. It seems to be generally that there's a few conditions that are still unsettled and things are happening. The one question that I have with respect to which comes first, the permitting process or the decision of the RGU, and just to put this out there, I mean, I feel some responsibility as with the EQB being the RGU that we have some stewardship over making an appropriate decision. So that's why all these questions. And then one that stuck in my mind that came up from some of the testimony was this, and maybe staff knows the answer, is if we were to postpone the decision on whether or not to, on the RGU, you know, either to complete the permitting process or to figure out what the scoping is of this project. And with the postponement of that RGU decision, say later we do decide, no, Erickson is out, and the permitting process in Houston had occurred, what happens then? Would Houston go through the RGU at that point, after the fact, or had the permitting process already been completed?
Well, if we acted on it, we would remove ourselves as the RGU for the Erickson mine. Still be the RGU.
My question is then does the RGU status go back to Houston, and would it be after the permitting process?
For that specific mine, yes.
And does Houston expect then, even if they go through the decisions on the permitting tomorrow night or whatever, to consider the status of this? And
you did hear from the chair, and the chair said yes, they'll consider. I believe paraphrasing what you said. I am, but I mean I think it's accurate. You said, of course, we'll consider all of those conditions.
We would take action as the RGU and go through the process that we already require by our ordinance for construction sand.
Is that
I just want to make
muddy
sure.
The water?
Yeah.
Mr. Chair, I also wanted to reiterate
Yeah, go ahead.
for the record that the Planning Commission meets tomorrow night. That doesn't automatically renew the permit. Planning Commission takes up their and makes a recommendation to the county board, if I'm not mistaken. Is that correct?
That is correct.
Thank you.
Mr. Chair, that is correct if the county's the RGU.
Right. Yeah.
Mr. Chair? Yeah.
Please come on up to the microphone. Welcome.
Thank you.
Good to see you here. Please identify yourself for the record.
My name is John Dustman. I'm a principal of Summit Environmental Solutions, a consulting firm here in St. Paul, and hopefully, Mr. Commissioner Stein, I can help you with some of your questions. The number of sites to bring forward in an EIS is obviously a very complicated issue for a business entity that is about to embark on something of this size. And the business climate, the economic climate, the political climate, all weighed factors. And Minnesota Sands has obviously been in a very tough position. When I got a call the day that somebody heard that the governor was going to ban frac sand mining in the state of Minnesota, somebody quoted him at the state fair. Well, obviously, that would weigh into somebody's decision to move forward with an endeavor to do an EIS. A year ago, there was talk about a statewide EIS. Again, that has to be weighed. If the state were going to jump in and do a statewide EIS, why would a project proposer take on probably what's going to be close to $2 million to do an EIS? In what counties? Counties that have moratoriums, counties that don't have moratoriums, counties that have moratoriums but extend the moratoriums, counties that are really in somewhat of a turmoil. And so we've kind of been advising Minnesota Sands all along. We got involved fairly late in the game. We actually drilled the borings at the sites in Houston County and kind of tried to characterize the resource that was there in addition to the dolomite that's obviously been mined at these sites that we're talking about. I'm not sure the board understands that. These are existing quarries, have been. So when we advised Minnesota Sands to go ahead and do a voluntary EIS, it was because we didn't feel, based on our experience, that it would be successful in the Yoder and Dodelstein issues, that they would be considered connected actions. It would increase, put them over the threshold, and then ultimately, after lots of wrangling and legal maneuvering, that it would be required anyway. With what was going on in Houston County, with permitted facilities, certainly Minnesota Sands didn't feel like they were going to be doing EISs on mines that already had permits. They were quarries, had been for years. The permits did not distinguish between dolomite and sand. And so they thought they were going to be able to generate a revenue source to fund the EIS by mining in Houston County. Hence the lawsuits that were going back and forth with Houston County, can permits revoked or temporary suspended? Not real sure. We're certainly not attorneys and have not gotten involved in any of that. But So then we decided, well, you know, if you're going to do this, Mr. Frick gets calls every day. Well, that might be an exaggeration. Maybe not a year ago. He gets calls all the time from people, landowners, who have this resource underneath their property. And why don't you throw my property into the EIS? And so when we met with Mr. Smyser and Ms. Hallback in my office in March of 2013, which had to have been literally within a week of your findings of fact, that unfortunately we weren't here. I'm not sure why. But we met with Mr. Smyser and Ms. Hallback, and we made it very clear that the EIS would depend on the cost. And it would depend on what the scope would depend on the cost. And we made it clear that conventional wisdom would say, well, let's just come back and do an EIS on Yoder and Davelstein, because the EIW is complete. There's 220 pages of comments. And for somebody with an environmental review and environmental permitting background, that seems like pretty straightforward to me. And that could be done. And it certainly wouldn't cost $2 million. And so that was kind of one idea that we had on the table. At the time, Mr. Frick's business associates were making different decisions because the city of St. Charles had decided to vote down the St. Charles farm to rail, then sand plant transload site. And so the investors that Mr. Frick had attracted to go forward with that project decided they didn't want to be involved. So the funding source for the EIS that he voluntarily did were no longer there. I would like for the record to note that Mr. Frick has had the income agreement for just 2 weeks longer than he waited for it. Okay, that meeting was in March. It'll be clear, that meeting was in March of 2013. The income agreement was not produced to Mr. Frick until the middle of October 2013. So I guess I don't feel like there's been an inordinate amount of time that's gone by, and with the different decisions that are being made on a county-state basis, the decisions for sites to bring to the EIS still haven't been made. It's not like they're hiding anything. It's kind of a changing dynamic. And so with Houston County in particular, it was basically hedging bets, Mr. Stein, or Commissioner Stein, excuse me. It was basically hedging a bet, because if they lost in Houston County in court or whatever it was, if they weren't going to recognize the existing permits of the quarries that had been mined, then if they were part of the EIS, about a year, 14 months, whatever it is, 18 months later, at the time when those mines converged, it would be likely that those mines would have been, covered under the EIS. Does that shed any light on any of this?
Thank you, Mr. Chair.
Commissioner Stein.
Thank you, Mr. Dussman, for stepping forward, and I appreciate the information. And I don't want to come across as argumentative, I want to understand your relationship. So are you advising Mr. Frick and Minnesota Sands? Do you have a contract with him on that regard?
Yes, we have been working for Minnesota Sands for about 2.5 years now.
Thank you. Yes. Do you have any relationship with Mr. and Mrs. Erickson?
No.
Okay. Have you done borings on Mr. Erickson's property?
Yes, I have.
The material that he's talking about mining, is it silica material or is it dolomite?
No, it is absolutely the Jordan sandstone. It is a Cambrian sandstone.
Thank you. So it is silica, but I mean, you raised the question of dolomite mining, which is used for different aggregate resource, crushed rock and so forth. I just wanted to be clear on the record. And I do appreciate your testimony. Thank you.
Thank you very much. Other questions? Seeing none, thank you so much for stepping forward. At this time, I'd like to ask Kelly Stank to please come on up, or as they say, come on down. Kelly, nice to see you again.
Good afternoon.
Please identify yourself for the record.
Kelly Stanage from Houston, Minnesota, and I'm here as a resident, a citizen, and I do currently serve on the Joint Agency Silica Sand Advisory Panel. Chair Frederickson and members of the board, before I get into my statement, I did want to clarify one thing. Our Soil and Water Conservation District Director Ron Miners, I'm not sure you may know him. His staff evidently did just do a survey of all the mines in Houston County, and they came up with an average size of 6.5 acres. So I just wanted to get that information out there. I think it's important, I'm very happy to see that you're giving this due diligence. I think it's very important, however, to understand the context. You're getting some of it, and I'm happy to see that. But this is obviously a complex issue that spans multiple authorities and has occurred over a couple of years now. My statement is intended to provide that context in order to aid you in making an informed decision. The Erickson site has been an occasionally used borrow pit in Houston County, as you've learned, for which a CUP was originally granted in 1992, and it was approved for 8,000 to 10,000 cubic yards of sand. And you see that in the J. Squires letter that's been referenced a couple times. Tracy Erickson purchased the property in December of 2009. And at some point after that, he apparently formed a business relationship with Minnesota Sands to mine silica sand from the old borrow pit. In June of 2012, G-Cubed, an engineering firm hired by Minnesota Sands, prepared an operations and reclamation plan for the silica sand mine. The estimated amount of silica sand to be mined was over 2 million cubic yards. That original 2012 plan with the cover letter from G-Cube starts on page 11 of the additional materials in your board packet. It was the packet that was sent out later. The Houston County Board of Commissioners issued a moratorium on silica sand mining in February of 2012. Minnesota Sands and Tracy Erickson came to some conclusion that the moratorium did not apply to them and began excavation at the site in July of that year. On July 10th, 2012, the county board issued a stop work order. Minnesota Sands and Tracy Erickson subsequently filed a lawsuit seeking, among other things, a temporary injunction to lift the stop work order. A citizen's petition for an EAW on the Erickson mine only, it was only on the Erickson mine, was submitted and approved by the EQB in August of 2012. The Houston County Board officially ordered the EAW that August. Erickson's and Minnesota Sands' request for an injunction was denied in November of 2012. The judge's memorandum, which is on page 72 of your packet, also noted that the more limited mining, which had gone on since 1992, could not proceed until the moratorium was lifted. In March of 2013, the EQB took on the RGU status for the 11 silica sand mines proposed by Minnesota Sands in Winona, Fillmore, and Houston counties. Attorney J. Squires' letter to Zoning Administrator Scanlon indicated that the CUP for the Erickson mine had expired in early 2013, and the expiration date has been mentioned as January of 2013. Since then, the EQB, as you've been discussing, has attempted to finalize the scoping phase of the multi-site EIS. Meanwhile, you've received numerous correspondence from several people, Jed Hommel, Rick Frank, Bob Scanlon, claiming that the business relationship has been dissolved. Jeff Smizer asked some good questions about that business relationship, which have not been answered in writing. And I think it's important to get answers to those questions. In the dissolution of contract agreement, which was penned evidently in September of 2012, it identifies several conditions that Commissioner Rothman had pointed out that must be met in order to achieve the dissolution of the business relationship. Point 6 of that agreement indicates Minnesota Sands will pay all attorney's fees to obtain Ericsson's existing permit back. That same existing permit, which Attorney Jay Squires had indicated was expired, it also further stipulates what the terms of that permit should be, making a distinction between sand and, quote, not frac sand, and that the permit terms shall be consistent with what Ericsson had prior to the lease agreement. Point 9 indicates that the parties will release and forever discharge each other from any and all claims in exchange for the aforementioned consideration. The fact is that the exchange for the aforementioned consideration has not occurred. Therefore, the actual dissolution has not occurred. They have agreed to the terms of the dissolution, but they've not yet dissolved the relationship because the terms have not been met. I also question whether the terms of the agreement can legally be met. Given the fact that the permit is expired, it should require a new permit. There is an outstanding citizen petitioned EAW on that specific site. There is new legislation regarding silica sand mining. We have also established that this is silica sand at this site, and the judge's ruling stated mining could not take place until after the moratorium was lifted. I would argue that there may well be, and certainly should be, additional conditions on any CUP that may be issued. In addition, according to the operation and reclamation plan, in your original packet forwarded to Carolyn Magnuson of the EQB by Bob Scanlon on May 7th of 2014, the scope of the project, according to the operations map, is the same as the proposal originally submitted by GQ in June of 2012. The document you received from Scanlon is the same document as originally proposed by Minnesota Sands with manual handwritten alterations to distances and entire sections including dust mitigation, safety fencing, and safety having apparently been manually blanked out. Several attachments from the June 2012 plan, which included a stormwater prevention plan, have also been omitted from the document sent by Scanlon. In addition, in the document submitted by Scanlon on May 7th, the excavation quantities on page 111 of your packet have been whited out. If you look at the excavation quantities on that same operations map in the additional packet, it indicates the excavation of 2,323,225 cubic yards. The project described in this document is over 200 times larger than the 8,000 to 10,000 cubic yards per year borrow pit originally permitted. So in summary, my points are, the terms of the dissolution of the business relationship have not been met, which means that the business relationship has not been dissolved. Until then, the Ericsson site should remain included in the multi-site EIS. This is a new, dramatically larger project. It is not the same as the originally permitted borrow pit. This appears to be an attempt to circumvent currently ordered environmental review as well as new legislation passed last year. If you intend for the new silica sand mining legislation to have any teeth at all, I respectfully suggest that you insist on follow-through for environmental review, trout stream permit setback permits, and any other relevant regulation for this project. Thank you for the time to speak.
Okay, thank you very much, Ms. Stanich. I watched your name again. I do it all of the time. I'd like to ask Marilyn Falconcorn, Bayer, and Joanna Roof. Come up. Really? I can botch those up too. Yep, yeah. Well, I think I nailed Joanna's name. I think I got that. So, welcome, close, yeah, sure. Welcome, both of you, to the committee. And please identify yourself for the record.
Happy to, sir.
Clearly.
My name is Marilyn Frown Crown Byer.
That's what I said.
All right, well said. Good afternoon, Mr. Chair and members of the board. Thank you for this opportunity to address the Environmental Quality Board. My name is Marilyn Frown Crown Byer, as we just established, and I am a lifelong resident of Houston County, whose family first settled there in 1866. So 7 subsequent generations of my family have chosen to call Houston County home. We, along with all Land Stewardship Project members, are greatly concerned about Minnesota Sand's environmental impact statement issue to be taken up at your meeting here today. The decision the Environmental Quality Board makes here regarding the Erickson Sand and Minnesota Sands LLC environmental impact statement has far-reaching repercussions for the health, the land, and the health of the people in southeastern Minnesota, as well as the integrity of the environmental review process. The operator of the Erickson mine now claims he is producing construction sand, not frac sand. We have established that sand is silica sand. On a side, I do hold a degree in geology, and no, not all rocks in Minnesota have silica in them. However, the proposed plans for the new operation are in essence identical to the frac sand operation proposal. Back in June of 2012, a company called EQB submitted permit application documents for the original frac sand mine proposed for the Erickson property. The documents in your EQB board packet appear to be the same documents with a new title page and certain portions manually masked out. For example, under the access heading on the second page, the old plan calls for dust mitigation on the access road, and the document in your packet does not include that point, but the space where it would have been is still there. The operations map is exactly the same, except the old earthworks excavation summary previously under the legend has been masked out. And at the bottom right corner of the page, Rick Frick has been masked out and replaced with handwritten Tracy Erickson. The area of the mine is the same. The minerals being extracted is the same. The names have been changed. Now some of the minor safeguards included in the original documents have been omitted. This looks like the same mine originally proposed. The potential for cumulative effects is still present, even more so if all the mines in Houston County are able to start mining silica sand under old permits. What would prevent Minnesota Sands LLC from starting a new LLC and entering into a new lease with the Ericksons? As I understand it, these sorts of shell games are all too common in these circles. This mine needs to stay in the ordered EIS, as the cumulative environmental impacts of the mining will be the same to southeastern Minnesota. The owner of the Minnesota Sands LLC claims he has severed ties with the Erickson mine owner and wants that mine removed from the EIS. Because of this, the EQB is considering removing the Erickson mine from the EIS. The EQB ordering the multi-site environmental impact statement, and becoming the responsible government unit has been by far the most significant state action to date to protect southeastern Minnesota from frac sand mining. The EQB has the authority and the obligation to deny this attempted end run around the environmental review process. Here are the factors we believe the EQB needs to keep in mind in making the decision to keep the Erickson mine as part of the EIS. The EQB has received incomplete information about the severing of the relationship between the mine owners and Minnesota Sands LLC, Minnesota Proppant LLC, Richard Frick. Number 2, according to the documents in the EQB board packet, the owners of the mine, Tracy and Michelle Erickson, have provided no information to the EQB at all prior to this meeting. All information has come from Houston County staff or Richard Frick. Number 3, more troubling, is the Erickson's proposed new project for construction sand is identical to the original one to produce frac sand. It is very possible this construction sand could be sold to some new enterprise operated or controlled by Mr. Frick and then sold as frac sand. The EQB has asked for full and complete information on the relationship between the mine owner and Mr. Frick, Minnesota Sands LLC and Minnesota Proppant LLC, and has not received it. In the March 25th, 2014 EQB letter to Mr. Frick, EQB staff write, quote, "Please describe in detail any association between the Tracy and Michelle Erickson site or Tracy and Michelle Erickson and Minnesota Sands LLC and or Minnesota Proppant LLC. This would include any past, current, or anticipated future associations and include but not be limited to a partnership, ownership, shareholder, buyer, seller, processor, transporter, or relationship of any kind, end quote. In a letter received by the EQB from Mr. Fricht on April 5th, 2014, there was a dissolution of contract with no explanation or the accompanying documents necessary to fully understand it, such as the original lease and/or the original agreement. As my grandfather used to say, there's something rotten in Denmark and it isn't the cheese. To the citizens watching this issue, it just does not pass our olfactory sensory test about this being a different proposal, nor about ensuring the relationship between Minnesota Sands LLC and the Ericssons is severed. The fact is, there is a lack of information despite the clear request from the EQB for more detailed information. There is a process for a variance from the environmental review process spelled out in rules. This process allows for public input and requires more detailed information from the proposer. This is the process which needs to be followed for the mining of silica sand at the site before the EIS is completed. The provisions for the variance are found in Minnesota Rule 4410.3100, subpart 4, 5, and 6. These provisions require, among other things, information about the anticipated environmental effects of undertaking the proposal, how approval would affect the purpose of environmental review, and public notice and comment. If an EQB order to remove the Erickson mine from the EIS would move forward at some time, despite the above facts, the order needs to state, number 1, a silica sand trout stream setback permit is required. Number 2, a previously started EAW on the mine must be completed. And number 3, the RGU for the environmental assessment worksheet will be the DNR. If the decision is made, the Erickson mine is no longer part of the EIS, the issue cannot properly just be handed back to Houston County. This proposed mine is within a mile of a trout stream and will require a DNR-issued silica sand trout stream setback permit to operate. The sand available at this site is silica sand, and calling it construction sand does not change this fact. There was an EAW in process when the Erickson mine was included in the EIS. That EAW still must be completed if the mine is removed from the EIS. While Houston County was named the RGU for the EAW at that time, the new requirement for a silica sand trout stream setback permit should require the DNR to be the RGU for the EAW as well. The importance of this decision cannot be overemphasized for the people of southeastern Minnesota. If the EQB simply allows the Erickson mine out of the EIS, then it is creating a blueprint for the other mines in the EIS to do the same thing. We urge you to reject this obvious attempt to circumvent this much-needed environmental review. Thank you again for this opportunity to address the Environmental Quality Board.
Thank you very much. I think we'll just go to Joanna, and then if you have questions, if you wouldn't mind just hanging in there, and if you have questions, we'll take questions for both of you. Thank you. Joanna?
All right. Good afternoon, Mr. Chair and members. My name is Johanna Ruprecht. I'm an organizer with Land Stewardship Project based in our Lewiston office in southeast Minnesota. First of all, I'm just passing out copies of the letter which was sent from the DNR in April to Mr. Erickson regarding the requirement for a silica sand trout stream setback permit at the site. Just would like to make sure you all have a copy of that. I don't believe it was in your packet. And then next, I'd like to make sure you're all aware of a little bit of the history of environmental review with the proposed Minnesota Sands project overall. What we've seen in the last couple of years is really a piecemeal approach and an attempt to avoid any EIS requirement on this project in spite of how clear it is and has been that the phase action rule does apply to what Minnesota Sands is doing. We've seen in Winona County in 2012, the Yoder and Doublestein mines, which are proposed there by Minnesota Sands, they put those through separate EAW processes and claimed that the landowners, the Yoder and Doublestein families, were the proposers. So they did not identify themselves, Minnesota Sands, as the proposer in that EAW process, basically in an attempt to show that they were not phased actions. They also, in those EAW documents, claimed that there was no relationship between the mines and Minnesota Proppant, proposing the frac sand processing plant in St. Charles, which was also not true. And it took extensive citizen organizing to get to the point that it became clear, yes, these are phased actions, and yes, Minnesota Sands is proposing phased actions that add up to well over the mandatory EIS threshold of 160 acres. They actually The 11 sites, which is the only list we have now, that's the list we have to go on until and unless anything else is submitted. The 11 sites in your original order from March 20th, 2013 for the EIS total 615 acres. So that is well above the 160 acre mandatory EIS threshold for sand mining. So for the proposers to refer to this as a voluntary EIS, you don't get to volunteer to do something that's mandatory. If you're proposing over 160 acres of sand mining, even if it's at multiple sites in the same environmentally relevant area, those are phased actions, that's mandatory EIS. So that's what we're dealing with here, and that has not changed. Again, the only list we have is those 11 sites, 615 acres. However, if you were to receive a new list without Houston County mines, which has been referred to as a possibility today, the Winona and Fillmore County sites within that original list still total well over 250 acres. It would still be a mandatory EIS that we're talking about. But again, it wasn't, it took substantial work on the part of citizens to get to the point where that law was being enforced and that the EIS was originally ordered. So I think what we're seeing here today is a continuation of that pattern of behavior of attempting to circumvent environmental review, and I'm very concerned about that, and I think you should be aware of that and concerned as well because of that history. Secondly, I'd also just like to make sure you are aware and are keeping in mind how high the level of citizen interest and concern is in this issue in southeast Minnesota, in Winona, Houston, and Fillmore counties, and the areas that would be directly impacted by this proposed project. You may remember last September, I shared with you copies of a document, the People's EIS Scoping Report, which LSP compiled from the comments that we received at a meeting we held last July in Rushford, Minnesota. We had 100 people packed into a church hall there. It's really the central to the area in which these proposed mines are located. People are very, very concerned about the impacts of this project on their lives and their homes and their communities. So please keep that in mind as you make any decisions about this issue. And that document is on our website. I encourage you to take a look at it again. It's called the People's EIS Scoping Report. Thirdly then, I want to reemphasize what you've heard about already, that you asked for more information on this situation from the project proposers. You very clearly made that request and you have not received it. All you've received in writing was a dissolution of contract without the original contract or lease agreement or really anything else to put that in context. And it's interesting that that dissolution document is dated September 2013. It was not brought before you for many months after that, and now the parties involved are saying, you know, you really can't wait any longer, we've had to wait too long. Well, they were waiting for some reason during that time. And so again, you really don't have the information before you. A lot of this seems to be on a verbal only basis. There just isn't enough information before you as far as documentation to be able to make a decision today that this project should be removed from the EIS. And so I would urge you not to make that decision today. However, if that is the road that you go down, there is still, as you've heard from several other people, there is still a requirement for an EAW on the Erickson project, which was citizen petition. It was ordered by Houston County, and I'd like to draw your attention once more to the letter from the attorney, Mr. Squires, in your packet from May of 2013. He says, the county board determined in its findings and EAW decision that any mining at the site required completion of an EAW. That determination was never challenged. Thus, in my opinion, the final action prohibition would apply in this case, and Erickson would not be allowed to mine until the EAW is complete. So, and this is their attorney's recommendation. It does not make any reference to Minnesota Sands or any relationship or lack thereof. It says any mining at the site. I don't really see how that could be any clearer that it is. And again, this was an EAW that was ordered by Houston County after a citizen petition. There isn't a mechanism in the rules that Houston County can just change their mind and say, we take it back and we unorder it. It was ordered. That requirement still stands, even if the Erickson mine were to be removed from the EIS, which I would urge you not to do. However, if that happens, they are still under that standing EAW order. Thank you. Any questions?
Thanks, Joanna. Questions for either testifiers? Commissioner Lambert?
Sure. Not so much a question, but you know, I'm not a geologist, but I want to go back to the fundamental. We have a statutory definition of what silica sand is, and just to paraphrase a couple things, it's well-rounded sand-sized grains of quartz, silicon dioxide, with very little impurities in terms of other minerals, but it also specifically does not include common rock, stone, aggregate, gravel, sand with a low quartz level, or silica compounds recovered as a byproduct of metallic mining. So it's very specific to a type of sand, and that's, I think to Commissioner Stein's question, that's what we find in that deposit.
All right, I think we're getting close. Other questions for either Joanna or Elizabeth? Or Marilyn, I'm sorry, yeah. Let's close.
You having a rough day.
I am having a rough day, yeah. None? Hearing none, or seeing none, thank you very much.
Thank you again.
For your
Thank
comments. I think we're getting close. Remember, I believe Kate pointed out we have 4 options in front of us. One of them is to adopt a resolution removing Piers and Mine from the phased and connected status. The other one is to amend and adopt. The other would be to table, no action, and, oh, there it is, okay, and or reject. So that's where we're at.
Mr. Chair.
Please.
I'm going to move that we table action on this until the next meeting, and I don't want this to come as a signal that we're not interested in making a decision. I'm interested in making a decision. I'm interested in the consequences to the landowners and to the county. However, the information we heard today was the first we've heard answers to some questions. I appreciate that from the owners. I do believe that a more affirmative statement from Mr. Frick regarding his intentions. He stated today that he does not intend to complete or have any projects in Houston County, and something describing that determination would be very helpful to have in writing before we take action. And I believe that even if the cost agreement and the scoping process has not begun, that kind of correspondence would be very useful for the board to have, and it would just set everyone on the same understanding before this property is determined to be outside the scope of a potential EIS. And I explained my reasoning for being frustrated, and I appreciate the board's indulgence. But with that, Mr. Chair, I move that we table action on this until the June board meeting.
You heard the motion. It does require a second. However, it is not debatable. So is there a second to the motion to table? Is there a second to the motion?
Mr. Chair, I'll second.
There is a second. Yeah, we'll have a roll call vote. I'll ask Executive Director Seifert to call the roll.
Chairman Frederickson?
No.
Commissioner Clark Stevens? No. Excuse me. Ms. Heidi Tollefson?
Yes.
Commissioner Ellender?
No.
Ms. Gehring?
Yes.
Ms. Knuth?
Yes.
Commissioner Lamwer?
No.
Commissioner Napstead?
No.
Commissioner Rothman?
Yes.
Mr. Saxon?
No.
Commissioner Stein?
Yes.
Mr. Tomlinson?
Yes.
Commissioner Zelli?
Yes.
Mr. Chair, did Commissioner Cronk vote?
Yeah, the motion is 7 to 5 to table. So the motion prevails. Thank you. The motion is laid on the table. We will move then to the next item of business. I'm sorry.
Just a closing observation. In this very controversial area, there are going to be strong positions on both sides. It's absolutely critical that it be good public process and public documentation. And I'm not seeing the good public documentation that the CUP was extended uninterrupted. And so I think we're going to have to make sure, and I'm going to throw that back to the county needs to provide that documentation that there is not a lapse in the permit. And it's perhaps not so much a discussion, a consideration for this discussion, but at this point in time, it would be my
belief that trout stream setback would be needed if any seine would be extracted. But I think the other element to that question is whether or not the EAW is still, the petition for the EAW, the requirement for the EAW is still standing, which everything I've seen suggests it is. And again, there are specific actions that need to be taken to start an EAW. There are specific actions that need to be done to deny an EAW. One of that, for instance, includes publication in the EQB Monitor. We have not had a request to publish an EQB Monitor. So the county has not followed the letter of the law and the rules, if that is in fact the position of the county and the other folks. So I just want to stress that it's going to be incredibly important when we get into this very contentious regulatory legal process that we have good public record, and I don't think we have that before us today.
All right, and again, I want to thank all of you for taking the time to participate in this 2.5-hour discussion. It's been, I think, highly educational, and we have really tried very hard to focus on the facts. So thank you very much. Okay.
Mr. Chairman.